talking about mobile phone handsets because they pose some really interesting problems in terms of technology and technology regulation, which is what the FCC's mandate is. So first up, what's up with the FCC? Why are they looking at this now? Senator Franken keeps up on Wired, I guess, and he caught all the flack about carrier IQ. I don't know if a lot of you know what carrier IQ is. It was called a rootkit by the hackers who found it because it ran without the user's knowledge, had access to things that the user did not, namely the baseband processor. And it collected data on what the user was doing and reported it back not to the carrier, but to a third party. Third party being carrier IQ. Some carriers claim that they didn't even have access to the data collected, just aggregated data from all the users that the data was collected on. Senator Franken, you might know him as a comedian, but he got elected to the Senate somehow.
It was a contested election.
Hotly contested. He saw this and he was alarmed because the power in tracking people on their handsets, you know everywhere they go. So he sent a letter out to the carriers and he wasn't really impressed with the responses, and so he went to the FCC through a standard process of petitioning to try and get new rules to control the use of these applications pushed out by the carriers. The FCC, following the Administrative Procedures Act, decided to consider action on this, posted a notice of considered rulemaking, and requested comments. It was a fairly short period that they requested these. They asked some really interesting questions. I have a short sample of what they asked here. What obligations do the carriers have to their customers? What third-party obligations do they have? All sorts of interesting questions about how users, carriers, and third parties should interact. The carriers kind of came up with some really lame stuff. We do just fine regulating ourselves. You don't need to worry about us, which is like, yeah, right. That's always been true, hasn't it, about AT&T and others?
Self-regulation worked out really well.
Yes. The Federal Trade Commission is also interested in privacy on the handset, and I'll talk more about that later, but they've also issued guidelines, I don't want to say threats, but declarations that privacy is something that is high on their priority list right now. And also they argue that the FCC doesn't have authority to regulate the handset itself. They maintain that the handset is a user-controlled device, so outside the FCC's authority to regulate in terms of telecommunications regulation. Also, the last argument is kind of doesn't gel with the others, and that is that this is necessary information to ensure a quality network. They talk about information like collecting missed calls. You try and make a call, it looks like you have signal and you're not able to complete the call. That's very interesting to them in terms of maintaining the quality of their network, which is a valid point. Talking about industry self-regulation, it's a joke, right? After people objected, carrier IQ was killed. It's still around. They are bringing it back under other names. I got a notice the other day saying that I have carrier IQ on my phone, and unless I root it, I can't get rid of it. I can't turn it off. I can't opt out. I'm with T-Mobile, they call the application system administrator, but if you read the details in the documentation they provided after the fact, there's no opt-out. And it includes carrier IQ. Some carriers are openly selling data. Verizon has a website dedicated to the business of data selling. And on this website, they suggest advertise recorrelate the data because they can't give it away with personally identifiable information, but they can give it in such a form that advertisers can recorrelate with outside databases to figure out who you are. Is this self-regulation? I can't imagine. Federal Trade Commission's role in all this, as I mentioned, they're deeply involved with improving mobile privacy. They spend a lot of time, and they've been holding conferences specifically for application developers to rethink what data they're collecting from the users. And the mobile developers I've spoken with, it's not even on their level of awareness that the kinds of data that they are able to collect is something that they should be concerned about. And I've spoken with a few, and they were really surprised at not only the fact that any data that they collect is subject, that they have to protect against security breaches and other things, but it's also fully subpoenaable. A third-party doctrine means that the relationship with them as a provider and somebody who stores data and an outside entity, say an aggrieved ex-wife, they're not able to prevent that third party from getting access to their own users' data. And so FTC is raising awareness on this, establishing privacy policies and adhering to privacy policies. Yes, the question.
Don't public utility commissions also have a role?
Yes, public utility commissions also have a role, but not on a national level. And I'll get more to the different government roles or specific federal communications roles. The Trade Commission supports the Communications Commission's actions on this. The argument that over-regulation because of two agencies regulating the same thing is simply not possible in this situation. They're really interested in working together. So the authority to regulate, FCC's been regulating this type of information, customer proprietary network information, CP&I, since 1934. The doctrine's been out there, it's been updated. Last time it's been updated was 1986. And it's surprising how comprehensive this is. Mobile privacy has only been included in the order from the FCC since 2007. So far, handsets are pretty much excluded. CP&I, it's all about the information. And I'm quoting the law, the statute here, specifically quantity, technical configuration, type, destination, location, and amount of use of service. This is all stuff, if you've ever managed a technical network, you recognize that every bit of this is important for providing a quality network, but it's all something that tells you something about the user. And so it's proprietary network information. It's necessary to run, but also necessary to protect. This is information that's made available to the carrier strictly because of the relationship. Because you're using the carrier's service, they get this information. Yes?
They do need a lot of it for billing.
Yes, yes. Billing information is also included on CP&I. And what's really interesting, there has been a court challenge to this, and it's been upheld. None of this information, even in aggregated, depersonalized form, can be available to market to the telco's own customers. Verizon tried to do this a few years ago and got slapped down. Anyone remember the Carter phone decision? Yeah. Anyone remember the Carter phone decision? If you study telecommunications at the collegiate level, they like to talk about it because it's what opened up the opportunity for the internet as we know it. There have been a lot of different opportunities to open up, but this one particularly allowed people to connect their own equipment to the network. Without it, we wouldn't be connecting modems, we wouldn't be connecting all these other devices. And basically what it said was, if the technical specifications are met, then by law you have to allow other competing vendors even to connect to the network. The AT&T, which was a monopoly at the time, argued against it at the time based on their concerns about people putting equipment on the network that would damage the network, that would impair quality, that would reduce customer expectations and raise these real concerns. But the FCC, as a result, it established a regulatory operation to certify equipment that would connect to the network. And so now every device, including your handsets that you're using that connect to the telephone network in any way, have been certified by the FCC to fit within carrier specifications. By the way, there's one other interesting feature of CP&I, and that's it must be disclosed to the customer upon request. That means that all this location data that your carrier is collecting, and by the way, they're collecting a lot of location data on you, not just from the handset, but also triangulation data they're required to collect by law to provide 911 services and locate a handset when it calls. Yes, in the back.
Just a quick question. So I know we had to use the couplers to modems until the mid-'80s because they wouldn't allow the equipment on the network, the full modems. So why did it take so long if the act was changed in '68?
Well, the issue was establishing interfaces. Up until the mid-'80s, the RJ11 jacks that we use now, they didn't have those. They had to break up the telephone suppliers because until the mid-'80s you were leasing your telephone handset. About that long. I'm not getting the timeline right on exactly when the crossover began, but it was a big administrative battle in terms of opening up the network. Europeans until the late 90s, I believe, and even later in some countries, had to use telephone vendor equipment to connect. I remember talking with friends who they couldn't get a modem. They had to use the telephone, lease a modem from the telephone company. So yes, CP&I has to be disclosed to the user. So if they're collecting data to improve their network, they have to be able, or you have to be able to get it. Currently, I believe it was Wired did a survey on which telephone vendors would give you which information and came up with a big fat zero. No telecommunications carrier will give you the location information. Sprint actually came up with a reason why, and it had to do with law enforcement subpoenas, but that's a whole other ugly ball of wax. Did I mention that Verizon's selling their data? This is an image I took from the site where they're advertising customer data to businesses who want to improve their advertising footprint. What's interesting is they have a really narrow privacy policy, and so they're able to sell this while adhering to their privacy policy. And what's interesting is they give you the ability to opt out, or they gave it to you. There was a 1-month window in which you could opt out, and you had to follow a very specific format. Opting in and opting out is interesting with telecommunications carriers. Another industry twist, they're saying, well, we can aggregate, depersonalize data and sell it, and it's perfectly legal that way, right? No. CP&I, if it's collected on users, they have very specific provisions for sharing aggregated data in the statute. And specific listed purposes. What's interesting is CP&I was not just meant for consumers. It was meant for switch vendors. It was meant for equipment interconnects, so that a telecommunications company working with a different telecommunications company could rely on their user data, their proprietary information, their trade secrets not being disseminated by virtue of interconnection. So even aggregated data is protected under CP&I. But the interesting issue and the point they're really niggling is identifiability. If data collected is identified, then it's CP&I. If it's scrubbed, what does scrubbing mean? What does identifiable mean? Every state, I believe, and the question about the public utilities commissions, every state has a different definition of PII. Those who work in privacy probably are familiar with the frustrating definitions that float around the issue, especially in the day and age where information can be recorrelated. If you collect enough information on a person, even if you don't know their name or their address, you can work backwards from there. Handset manufacturers are an interesting player in here. I mentioned earlier that CP&I order was meant to deal with different vendors as well. As soon as you start connecting to the network, you are subject to this regulation. So even a handset carrier or vendor is responsible, which makes Apple an interesting situation. They'll soon probably be more regulated by the FCC than they currently are because they have a lot of control over your iPhone that you don't have. They haven't turned that over to you. So any regulation that happens to go through here won't just affect the carriers. But Apple didn't weigh in on this whole consideration this time, which I find interesting. Well, what I'd like to think is Apple is okay with regulation, and they'd be happy to work with the FCC to make sure that your data is kept private. That's, maybe it's wishful thinking, but I'd like to. Yes, we'll see what happens. So these are other organizations that have come out against any further regulation. Direct Marketing Association, usual suspects. The vast majority of all data that's collected, the real value there, the money that's to be made, is in advertising. There are some other issues, like the Consumer Banking Association is on both sides of the issue. They want somebody to be responsible for breaches at the handset because they recognize that it's going to cost them one way or another if there are handset data breaches. But at the same time, they want that advertising data. They want to know what their customers are doing and where they're going and what else is going on with them, so they can better serve them. Another interesting twist is the Alarm Industry Association. It's great to put a wireless device on your alarm. You can never cut those cables, but how would handset style regulation affect the alarm industry? I think for the most part, since they control that device, there's no concern at all. So long as they're not, the carriers aren't somehow nefariously collecting information from these devices. On the consumer side, there are a lot of people who came out. Epic is one I'd like to call attention to. It's not as well known. Everybody knows EFF. But Epic actually was petitioned for the 2007 consumer privacy update. Oh, he's probably laughing. There are some really interesting players on here, like the Hispanic technology and telecommunications. That's pretty clever. But also, I found it really astonishing. The Catholic bishops and other clergy were really interested in privacy at the handset. What's really interesting. But seriously, the clergy are really concerned. They have had awareness raised about the children's privacy rights, and many parents give their kids cell phones. I was kind of appalled when my sister gave my nieces cell phones, but it raises the ability for the parents to communicate and keep in touch with the children's activities. But at the same time, who else is keeping in touch? And it also raises COPA issues, which back again, Children's Online Privacy Act applies to websites and that sort of thing, and it's handled by the Trade Commission, but it doesn't actually say anything about handsets. HTTP, the Hispanic group, is really concerned about minorities and how this disproportionately affects poor people and minorities, because they use these mobile handsets. They're cheap, they're easy to get. You can get online immediately, and it's much easier than buying a computer, buying an internet connection in a fixed place that you maybe don't have a fixed residence. And the handsets give minorities and people who are wishing to improve themselves a leg up. So it's really important to consider that. A question? Can you go back one slide? I can go back one slide. Oh, okay. I can also tell you where to get this information online, and I have that in my references. Okay. You got it? I have limited time, so I'd like to move on. Okay. So the way I look at it, there are really two approaches to regulation. The first approach is give the users more control, and the second approach is to hold carriers more responsible. I think a hybrid approach is really important. There are a lot of sheep out there. We all know this. There are a lot of people who are unable to protect themselves and have to have somebody that they can trust. Currently, they trust the carriers, and that trust is misplaced. By holding the carriers more responsible, that trust is less misplaced. But we also run into the concern that people in this room are, how many have rooted phones? No, he's not. But the idea is that if you want to have control over your phone, if you're knowledgeable and skillful, what is your ability? Are you going to have to root your phone in order to get at it? And if you root your phone, will the carrier still be held responsible? I think a hybrid solution can be found. Okay. And then the question arises, who owns malware? Obviously the hacker does, but who is responsible? And if responsibility for data breaches, for hacks, for maintaining the security of the device is, it can be used as incentive. If the carrier's not responsible, then they don't have control. And using that as a trade-off to currently one of the big problems is, and the reason I think the question is cost here is funny, is because the vast majority of all, most exploits, Android is the most exploited operating system right now. Most exploits are from applications that are downloaded from third parties and rooted phones. Because in rooting, you don't lock everything back down again. You wind up with open root passwords, ADB left on, all these issues associated or necessary to break into the phone are also make you more vulnerable. If there's a way you could control your phone without making it more vulnerable, I think that would be a win for everyone as well. So what should regulation look like? Carriers should be held accountable for everything the user cannot control. The opt-in schemes with opt-out availability. Verizon's idea that you get 1 month to opt out is not cool. That's not the way you give users a real choice about what you're collecting on them and what they're doing. I still think it's important to allow data collection, but in contracts there's something known as consideration. That's if I give you something, I expect something in return. Right now, the customers, the consumers are giving the carriers data and getting nothing in return. So that's not an arm's length transaction. That's a adhesion. That's a way to abuse your customers, basically. Carriers need incentive to grant users control by holding them liable for the things that they do control, for holding them responsible for any breaches on their clock. I think that's the most effective way. So, as an added bonus for this regulation, folding location data into CP&I, which it really should have been by statute to begin with, allows you to collect it. There's a lot less ambiguity in law enforcement requests. Currently, law enforcement requests, there are some carriers that just have a web interface where the law enforcement officers have a login and they can just ask for whatever they want in terms of location data, which you can't, by the way. I think I mentioned that. So law enforcement can just log in and ask for the data, and they'll be given it. FBI typically applies for a probable cause warrant. Other law enforcement agencies play more fast and loose. You especially see local law enforcement agencies, the people you're most concerned about with corruption and looking up somebody's data just for kicks. You see that a lot more at the local level, and it's a real problem that the courts have yet to deal with. By folding it into CP&I, it'll make the legal issues surrounding that a lot more cut and dry. So it still wouldn't raise the need for a probable cause warrant, but it would improve that significantly. The likeliness that this is going to happen. What I'm describing is a process that started in roughly May of, well, it started with the hackers who discovered Carrier IQ running on their phones, but it's politically started in May of this year. And we're looking at a pro-privacy Congress. They've taken a lot of beatings for, I don't know if you followed all the different issues with exigent letters and national security letters and all the drones and all the different forms of privacy invasion that they've accepted because of national security concerns. This gives them a way to put forth, oh yes, I'm all for your privacy because there are no national security concerns here. This is an issue of commercial interests fighting each other. The advertisers, the carriers, the people who want your data are not in it for the terrorism. So even the General Accounting Office, the staid, dry people who issue reports, research issues, have come out in strong favor of increasing user privacy online and electronically. There will probably be new regulations soon. The telcos will sue. I'm going out on a limb and saying they will not win because the courts are notoriously fickle in this regard. If law enforcement steps up and says, hey, we need something here, then the courts almost always give it to them, which is a little bit of a problem. So enforcement's going to be ugly. Right now, carriers file CP&I statements every year saying, we didn't have a data breach. This is like corporate statements, annual statements saying we didn't have a data breach. What constitutes a data breach? And all the information security concerns surrounding that. But regardless of what kind of a mess it is, how bad it becomes, the customers will win. At worst case, they could get something for giving up their data instead of just giving it up for free. So I would like to briefly talk about the process. This is I outlined the 2007 process where they went through the steps of regulation. The first step in changing the regulation, they issue the notice. Then they go on to a comment period. In the regulation that I'm looking at, the comment period was 30 days with a 15-day reply period, which is in regulatory circles extremely brief. Typical regulation, they'll leave the comments open for up to a year, sometimes more. But this is the minimum statutorily required comment period. In the previous notice and comments, there were 399 comments logged. You can find all of these comments online on the FCC's website. Anything that's published, any complaint, any issue regarding a notice and comment period regarding rulemaking changes is posted online for anybody to view. There were only 37 comments logged here, which is really bizarre. I've been talking to my faculty advisors on this, and it's like, really, only 37? There's something weird going on here, and nobody's quite sure what, other than the obvious issue that it's really hard to make any significant arguments against this. So June 8th, 2007 was when they came up with the last regulation. So it was about a year start to finish. So this one, it started in May. We might see something by the end of the year even, or possibly early next year. I'm hoping. It could be 2 or more years that things are logged. I also put together, this is the complete list of questions that the FCC asked in this notice. It's pretty detailed. There are 6 highly detailed questions. All of them, I believe, reflect an understanding of the issues. They're concerned about the roles of third parties in locked devices locked to service providers, advantages and disadvantages of clarifying mobile service providers' obligations, if any, with respect to information stored on devices. All very meaningful questions. So I don't think any carrier actually answered all of those, or any respondent answered all of those. EFF got a lot more into the technical details, but that's pretty much it. Anyway, does anybody have any questions, comments in the back?
Yes, I have a question. As far as, well, the great presentation, by the way.
Thanks.
And then as far as the data retention of our information, kind of like specifically like, like Verizon's kind of what it was. It's like 5 years or 10 years, much hard drive space for that.
Right. CP&I doesn't really cover data retention. Mostly, it just there are other statutes in terms of financial reporting and that sort of thing. That's more a trade commission area. So.
But I mean, like your location, for instance.
My location, right? Oh, there's there.
10 years ago, yeah, you were in Colorado.
Right. There's no, and that's an interesting question because in the article, in the threat level article that covered carriers who will reveal your data to you, basically no one. In the same article, they covered retention periods. There's a minimum billing retention period because if you want to challenge your bill, they have to store that data. But there's no maximum retention. So I know T-Mobile does the minimum, and the interesting thing is there's no incentive for other than the cost of storage for carriers to not store it. So, any more questions? Come on, guys. In the Hawaiian shirt.
It's not off topic. Is there any further progress on banning cell phone companies from just turning off their networks whenever they want to?
Oh, the question about banning companies from turning off their networks. That's actually a different FCC action. There are comments that are posted. I have references. If you go to the FCC's website, they have different codes for different rulemaking and different public notice submissions. I pulled some data for a larger paper I'm working on to talk about the utility and how important cell phones are. You can go up and see all the comments that are posted on that. It's enough comments that it looks like it'll probably be, the 1 to 2 year time frame before they make any determination on the carrier's ability to shut down the cell site at whim. So it's something that's in the works, but it's still within the time frame of making any sort of a decision on that. So.
There's a lot of, I saw a couple questions in there about data custody and control.
Right.
So if you have a non-rooted cell phone, is that a cell phone that's in your custody and control? Or is that considered to be in the custody and control of the mobile companies that's loading software out there?
Well, the question is data custody and control. Currently, there is the current rule states that everything is, or decision is that everything that is on your handset is in your custody and control because it's on your handset. And the part of the whole point of this exercise is that the cell carriers maintain control of data, and since it's legally in your control, there's that tension between who legally controls it and who in fact controls it. And by establishing rules that whoever controls the data is responsible for it is very important at this point. And that's what the carriers are, or the FCC's recognizing with this series of questions. So, yes.
You mentioned it briefly, but can you access your own data? Can you make a request to a company to get access to your own data?
You cannot access your own data. There is no regulation concerning this data, so they are under no obligation to share it back with you. So the only way you can access it is to hack your phone and try and access the applications that they push to your phone to collect data. That's about the only way I can think to do that. And it's perfectly legal to hack your own phone. Yes, in the back.
Have you heard of any progress on the Electronic Communications Privacy Act, the 6-month abandoned email issue?
I haven't really gotten into the Electronic Communication Privacy Act that deeply. It has some weight on this, but it's not really significant in terms of the rules on the handset, because it is a device in your hands. It's like your laptop, something like that. Over here.
Do you know if anyone has ever proposed legislation that would allow users to gain access to data which pertain to them?
I don't know if there's proposed legislation allowing users access. I suspect I wouldn't see that in legislation. I would see that in the Federal Trade Commission's rules, because they're really concerned about unfair business practices and deceptive trade practices, and those two drive a lot of their privacy decisions at this point.
How would one get the FTC to institute such regulation?
A petition for rulemaking. And and this is one thing that I would like to emphasize. Any citizen can petition for a rulemaking. Any organization can. Here, Senator Franken did. In the last one, Electronic Privacy Information, EPIC. It's really interesting. EPIC CP&I was the last order, but EPIC petitioned last time, and anyone, any individual, any organization can do that. Over here.
How would this apply toward the people doing voice over IP or services like Google Voice, for example?
Voice over IP is a different animal.
IP over handset.
Yeah, voice over IP has its own set of regulatory controls, and most of those have to do with the voice network interface, because you can have video over IP and all sorts of other things that aren't really regulated until they hit the public switch telephone network. When they do, then it becomes a thing. But it's really that interface that makes it interesting. And so whether you're doing it on your handset or on your desktop or you have a specialized device, these are all kind of independent inquiries. So, over here I saw somebody earlier. Is that? There is one more thing I would like to point out, and that is how very important it is to keep in mind how this whole process started. This process started with a bunch of hackers who were curious. Maybe they saw the German politician's infographic, which is really cool, by the way. It's the first one on the references, where you could follow this politician around for 3 months. Maybe they just found this file on their cell phone and wanted to poke around and see what was creating it, because there's a lot of data that was stored on their cell phones without their consent, without their knowledge or consent. So, and that was challenged and upheld. But who has the authority to control that is yeah, sure, the user. So it was hackers that initiated this whole process, and it was hackers who were loud and hackers who got hurt. Later on, there's a session about getting your hack disclosed, and I think that's kind of an important thing. Over here. I'm having trouble hearing you.
You mentioned it would be completely legal to hack your own phone. Does that mean it would then be potentially legal to write a daemon to pre-scrub what they're storing and then forwarding to their systems?
I think that's reasonable. I wouldn't mess around too much with the baseband stuff, because that's where you start getting into signals and signal quality, and that's why no ROMs touch that. But carrier IQ does, which is really problematic, because it's something beyond your control, and it's storing it in areas and crossing that barrier. So, any more questions? Oh, here?
Do these rules affect both data that is collected on the handset and then reported back, and data that's collected at the APN level on the cell network, or is it only handset?
Okay, right. The question was, does it just control data on the handset or other data as well? The location privacy stuff that's a big thing for me, because that's collected at the towers. You don't even have to have GPS or any location tracking on your handset, although most handsets these days have the embedded chip that you can't control. It should be immaterial whether where it's collected in the network, if the carrier has control of it. And I'm really surprised that the location data is not more tightly controlled, since it is a statutory issue. But I don't believe it's specifically been addressed by this, but I believe it's within the questions that they asked. So, any more questions? Okay, well, thank you all very much, and